Next matter to come before the court, State of Ohio versus Eileen Amato, 2023 CRCI 0490. This matter is set for a bond review hearing. The defendant is present with counsel, Mr. Brown. State is represented by Assistant Prosecuting Attorney Joy Marullo. Mr. Marullo, it appears that you have filed an updated bond recommendation.
That's correct.
The state is not pursuing a no bond order, is that correct?
That's correct.
Your recommendation is for a bond of $250,000, 10%. Is there anything you want to add to that?
Nothing other than what's contained in the recommendation, Your Honor. Basically, given the defendant's prior history of OVIs, two prior felony OVIs for which she had served, well, she was sentenced 2 years in one and 1 year in the other. In this case, she had a .127 blood alcohol content when she ran the stop sign.
Point what? 217?
127. When she ran the stop sign.
Did you say? I'm sorry. Did you say .217? .127.
When she ran the stop sign in Mountain Creek going north, she ran the stop sign, entered the intersection of 585 and struck a semi-truck trailer. Fortunately, it wasn't a large vehicle and not a small vehicle. The state contends.
Is that from a report? It's my understanding it's a semi-truck.
No, I think she. You could.
Do you have a report after that?
It's in the But Your Honor, the defense.
I don't really matter who hit who
It
here.
doesn't matter.
Yeah.
She blew the stop sign. The state's position that, given her history of OVIs, the fact that she's still drinking and driving after being sentenced to 2 years and 1 year, that she is a danger to society.
Is she currently on probation?
Not that I'm aware of.
Do you know when the prior felony OVIs were?
I can use that information.
According to the indictment, it was 2013.
Both of them?
Well, there were a total of 5 in just over 20 years. The last 2 were felonies.
The indictment only refers to the one from 2013. That's referred to the OVIs.
That's what?
I said the indictment only refers to the one from 2013. It doesn't refer to any other OVIs. It just refers to the one from 2013. So I'm assuming that's the most recent one.
Yeah.
So most recent felony OVI 2013. There's one prior to that, but we don't know the year. Is that accurate?
I can give you that.
And we have a total of 5 OVIs.
Lifetime.
Lifetime.
I'm sorry, 2013 the most recent felony, 2009 felony, and then 4 misdemeanors between 2001 and 2001.
Thank you. Mr. Brown, on behalf of Ms. Amato.
Yeah, thank you, Your Honor. My understanding from speaking to my client, I just want to be clear because I think this matters. She didn't blow through a stop sign. In other words, she didn't continuously go, didn't slow down. She stopped at the stop sign and looked, but didn't see the oncoming traffic and pulled out in front of the truck. I think that's very different than blowing through a stop sign. It's a much less dangerous situation. In this case, we have a .127 BAC that's alleged, Your Honor. It's not a high test. She's had no OVIs in the last 11 years. She's retired. Eileen is retired, so she doesn't have a substantial income. She lives in North Royalton, Ohio. She owns a house there. The address is 4330 Sir Robert Avenue in North Royalton. That's where she would be staying. She stays with her son, her daughter, and her daughter-in-law. Is that right?
My son-in-law, my daughter, and my granddaughter.
Oh, I'm sorry. Okay, so she lives with family there. There's no one of concern in the residence. $250,000 is a very high bond, and that's higher than bonds that we see in murder cases, Your Honor. I understand this is a felony OVI, but there's been no priors in the last 11 years. So in this case, I asked the court to order something substantially lower than that for a number of reasons. Number one, that my client's retired and won't be able to afford a bond that high. Number two, there's no indication that she's not going to show up to court. As far as we know, for purposes of this hearing, there's no history of not showing up to court, so that's what the purpose of the bond is, to get a defendant to show up to court. There's simply no indication that she's not going to do that. She's hired counsel. She's going to appear at all the court hearings. So I just think $250,000, there's been no offenses in the last 11 years is excessive in this case, Your Honor. Thank you. Oh, also, one other thing I wanted to mention, my client does take medication for blood clots. She had a heart issue where she had a blockage. And if she's in jail, it's very difficult for her to get that medication. That could be a serious issue as well. Thank you.
Thank you. So we've got a case where there's an accident. The defendant has 5 prior OVIs, including 2 felony OVIs. Those felony OVIs were from, well, they're not recent. They're from 2009, 2013. There is evidence that the defendant was, in fact, over the per se limit. The court is going to set defendant's bond at $150,000, 10% cash or surety. I'm going to impose the following conditions on your bond, Ms. Amato. You are going to be subject to a continuous alcohol monitor. You are not permitted to possess, use, or consume in any form alcoholic beverages or alcohol. You are not permitted to be in any place where alcohol is served. I caution you that alcohol monitor does not blink. The slightest bit of alcohol consumed by you will show up on that, and our monitoring department will know about it within about 3 minutes. If you drink alcohol at any time while you're on this bond, I will revoke your bond and immediately order your arrest. After that, I will reset your bond, taking that fact that you could not comply with these conditions into account. Do you understand? Do you understand your obligations in this regard?
I do.
Under no circumstances are you using, possessing, consuming alcohol. It's not in your house. And I don't care if someone else owns it. It's not in where you're living. Do you have any questions? There is a fee for the alcohol monitor. You will need to be responsible for that. Our probation department will talk to you about that and let you know what that's going to be. Due to the hour, we're probably not going to get that alcohol monitor on you today, but by tomorrow, that monitor should be on, and you should be ready to go, assuming that you're going to post the bond. All right, do you have any questions? Anything further from counsel?
No, Your Honor.
All right, thank you. Did you get that? That takes us to Mr. Leedy. Mr. Leonard, are you ready?
Yes, Your Honor, I do.
Could you give me a notepad?
I do have a question. Whatever the reason, Your Honor, it appears that this is another no bond hearing, yet in my paperwork that we received from the court, I said it was an notification that the appropriate motion was filed. I'm not saying it didn't occur, I'm just saying I don't have any indication of it.
Did you file a motion, Mr. Leonard, or Mr. Murillo?
In order to hear that motion directly, so I take that back, Your Honor. The reason that it was filed 9/23/12
I see it here on line 47.
Yeah, well, that's fine, I just want to make sure we're on the same page, and I can deal with it.
Right, Mr. Murillo, are you prepared to proceed?
Stay prepared, Your Honor.
Mr. Leonard?
Yes, I'm willing to as well.
Next matter to come before the court, State of Ohio versus Seth Leedy, 2024 CRCI 0457. This matter is set for a hearing on the state's application for a no bond order. The defendant is present with counsel, Mr. Leonard. The state is represented by Assistant Prosecuting Attorney Joey Murillo. Mr. Murillo, you may call your first witness.
Your Honor, the state calls Detective Belcher.
Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
You may be seated. If you could state your full name for the record, spelling your last, please.
William Belcher, E-L-C-H-E-R.
You may begin.
Your Honor, for the purpose of today's hearing, I'm prepared to stipulate to the detective's credentials and training, and I'm familiar with his work.
All right, that'll be noted. Thank you.
Can I just have one brief moment, Your Honor?
You may.
My notebook. Yeah, not bad. Did I put one right there? You need a notebook? Yeah. Okay. You good, Mr. Leonard?
I'm sorry, Your Honor, just please one more moment, I apologize. Yes, I'm real prepared, thank you.
All right, you may continue.
Detective Belcher, are you currently employed with the Worcester Police Department?
Yes, I am.
Are you familiar with an individual named Seth Leedy?
Yes.
And how are you familiar with Mr. Leedy?
I've been investigating Mr. Leedy since 2013.
Is Mr. Seth Leedy in court today?
Yes, it is.
Can you point him out, please?
He's wearing an orange gel shirt with his attorney.
Thank you. Your Honor, I'd like the record to reflect that Detective Belcher identifies Seth Leedy And can you tell the court on how many occasions J.L. 11/21/2006 said he was penetrated anally?
The indictment is for, I believe, 4 counts for sexual assault, but he had disclosed it happened numerous times from the time that he was 6 years old until he was 12.
And these incidents occurred in Wayne County?
Yes.
And do you have a date range of when these occurred?
2012, November 2012, through the last one was 2018.
I'm sorry, what was the last date you said?
2018 was the last year.
Thank you.
And I believe you said that these occurrences were disclosed to the CAC.
Yes, child advocacy center.
The Child Advocacy Center is an organization that interviews minor victims of sexual assault.
Correct.
Were there allegations regarding the same minor gross sexual imposition?
Yes.
And how many instances of GSI were disclosed?
2.
And do you have the date ranges of those incidents?
November 2012, and the second one until 2018, so there was a 6-year period.
And again, that occurred in Wayne County?
Yes.
Did you investigate allegations regarding another minor child, initials J.W., date of birth, March 12, 2003?
Yes.
Okay, was J.W. interviewed by the Children's Advocacy Center?
Yes, more than one time.
And what did J.W. disclose?
She was sexually assaulted by Mr. Leedy, and she was also shown pornography and porn.
Did J.W. disclose penetration?
Yes.
Did she disclose incidents that were not gross sexual imposition?
Yes.
And again, that would occur in Wayne County?
Correct.
Was another minor child, same initials J.L., with a different date of birth, May 16, 2004, involved in this investigation?
Yes.
What did you say the date of birth was?
Here you go, John.
You may.
Prepared to consent to a no bond here at this point, move on at this point. I'm not getting anything strategically from a defense perspective, and all Joey's doing is having him read from a report appropriately, but there's nothing gained here for me, nothing gained for the state.
Mr. Leonard, you wanted to address the court?
Yes, I've had the opportunity to speak to my client, Mr. Murillo, based on the information that I have received and obtained. We were prepared at this point in time to consent or concede that no bond would be the appropriate finding by the court. If for some reason we receive any new facts that would make that, in our minds, a different position, we would petition the court accordingly. At this point in time, we're prepared to bond.
Thank you. All right, you may sit down, sir. All right, based upon the concession of the defendant that a no bond order is appropriate, and that would be under revised code 2937.222, the court is going to order that the defendant be held with no bond. If the defendant decides to raise that issue, he may do so by motion at a later date. Matter will be set for a pretrial conference. I believe it's actually already set. Is there anything further?
Yeah, no, Your Honor, that's correct. It is.
All right, thank you. That'll be all. That takes us to Mr. Cornwell.